I'm Karima Brown. It's Sunday and it's time for The Fix. Welcome to this edition of The Fix, where every Sunday we hold those in power to account. We tell you why it matters, how it affects you, and why you should care. Now, Justice Minister Ronald Lamola recently appointed retired Judge Kate O Regan as the judge designate during COVID-19 to ensure that the tracing and tracking of citizens through the use of their personal data is not abused by the state. Talking to the media for the first time since her appointment, I'm now joined via Skype by former Constitutional Court Judge Kate O Regan. Justice O Regan, thank you so much for taking time out to speak to us. Now, of course, you've been appointed in terms of regulation, Section 27(2) of the Disaster Management Act. And, of course, you are supposed to ensure that the information that we are using to beat back the virus isn't abused. Just tell our viewers what exactly you do and how many people you have signed off so far in terms of using the information to track them, to find them in terms of testing them or screening them for the virus.
Good morning, Karima, and good morning to your viewers. It's a relatively focused role that I perform, and that is that government has decided that it should create a database of all the people that have tested positive for COVID-19 and those people that have come into close contact with them or are expected or suspected to have come in close contact with them. The major way that that database is compiled is through the information government gets from the laboratory tests that are performed. When you go to test for COVID-19, your details, which are basically your name, your ID number, your residential address, and your cell phone number, are communicated to those in the Department of Health who are responsible for compiling the database. And that's the basic way in which information is gained.
Now, if the information is gained that way, which official in Cabinet signs off on using someone's personal data? Is it the Minister of Health? Is it the Minister of Justice? Who from the Cabinet do you interact with? And how does it happen when someone wants to track somebody's information? Do they simply just enter their data into a system? Do they contact the cell phone companies? How exactly does it work, and on whose authority does it happen?
Yes, well, in addition to the compilation of data from laboratories, the regulations permit the Department of Health, which is the department and ministry that's responsible for the compilation of the database, to contact cell phone numbers to provide location information about those cell phone numbers, which are the cell phone numbers of people who have tested positive or people who are suspected to come into contact with them. That's the role, that's where my role comes in, because once the cell phone companies provide that information to government, the Department of Health must provide me on a weekly basis with a report of the names and details of the people who've been included in the database as a result of the information obtained from the cell phone companies. So far, I mean, we're still in setting up this process. So far, that has not happened, so I haven't seen any information of that. I can't say that nobody's information has been gained from cell phone companies, but a week hasn't passed since it has been, and government has not yet provided it to me. But it is important. The question you ask is an important one, which is who's responsible in government, and it is clearly the Department of Health. It's also very clear from the regulations that this information may only be used for combating COVID-19. So it can't be used in relation to the investigation of crime. It can't be used for other purposes at all. Any other use by government would be unlawful.
Now, how do you determine, Justice O Regan, when there is foul play? What is it that the Health Department must submit to you by way of details? And against what do you measure it to make sure that it meets the criteria of the Act as set down in the Disaster Act?
Yes. Well, this is one of the difficulties, isn't it, with any database, in the sense that the improper use of a database is very often very difficult to detect, not only by somebody like me, but by government itself. So that really comes to the second part of the role that the designated judge has, and that is to make recommendations not only to health, but also to the Departments of Justice and Cooperative Governance and Traditional Affairs, which is the lead department in relation to the declaration of the state of disaster, under which all these regulations have been made. And clearly one of the key things there would be ensuring that, as best possible, the best technology is used to ensure that the database is indeed secured from improper use, both from public and private sources.
At what point, Justice O Regan, will you be able to detect that improper use is actually taking place, or that the bona fides of the health department isn't what it should be? What are you using as a yardstick to ensure that you are not being conned, for example, that the information that is required isn't actually for COVID-19?
Well, I think that this is going to be something that is not so much going to be determined by me. It's going to come out, as it were, along the way. So, for example, if a government were to want to use information it gained from the COVID-19 database for purposes other than that, for example, in criminal proceedings or civil proceedings, it would be very clear that that would be unlawful, and courts would have an important role to play in that. Similarly, I think it's important to realize that the actual adjudication of lawfulness will remain a task for the courts. And as we know from the statement from Chief Justice Mogoeng, the courts will remain open for urgent matters during the period of the state of disaster. So getting relief in relation to an individual case where you suspect that there's been improper use is not something that I would be able to determine, because I'm not sitting as a judge in this context, but which the ordinary courts would have the authority and jurisdiction to decide.
Now, obviously, this information is vital. We are in uncharted waters, and of course, we are a rights-based country. We've got a Bill of Rights, we've got a constitution, but we've seen in more closed societies, for example, China, every citizen having a code and people having to punch in their information kind of as they go along. As someone who's served on the Constitutional Court, who's been part of developing that rights-based culture in South Africa, are you comfortable that the measures that government has put in place, Justice O Regan, are sufficient to guard against an authoritarian creep that we have seen in other societies and that some people are worried about in South Africa?
It's obviously something we should all be worried about and we should all keep an eye on. My sense is that we are still at the very early days of trying to work out how to manage this pandemic. There is no doubt that privacy rights are implicated by having your location data communicated from your cell phone company to government. But we also recognize that privacy is not absolute, that there are times when privacy rights can be limited. And here, one of the most important reasons for limiting privacy rights is another right in the Constitution, which is the right of access to healthcare. And what is clear is that if the pandemic gets out of control in South Africa, then all of our rights of access to healthcare are going to be threatened. It's in those circumstances, and it's not unusual, where two rights come in conflict, where you need to try and build a system which protects both of them as to the greatest extent possible. And I think that there is a serious indications in these regulations that government is seeking to do that. There are a number of safeguards, including the creation of the designated judge, but more importantly, the purpose for which the information can be put, the clear sunset clauses, which mean that the database collection of information and the database must be stopped shortly after the end of the state of disaster. Not only that, but after the end of the state of disaster, all those people whose information has been tracked as a result of this provision will be informed of that, which will enable them to determine whether there may have been perhaps illegal use by public or private sources of that information. So there are a range of safeguards set into the regulations. Again, however, I'm currently not sitting as a Constitutional Court judge on this, and this is a matter if people consider that there has been an infringement of their rights as a result of these regulations, in which the ordinary court processes will apply and applications to court may well happen.
Now, Judge, Justice O Regan, I just want to come in here. We have a series of individuals that have tested positive that we can't allocate. We can't allocate them to a province. We know that some people have gone missing. And in the case of the Eastern Cape, we've even had a situation where someone has broken the quarantine. Obviously, in those instances, that person's right to privacy is trumped by the right to save lives and, of course, also the right to secure other people's public health. How do you step in a situation like that? We've got, I think, over about a few, over 20 or so unlocated cases. Have that information been requested? Have you gotten an indication that those people are being tracked down? Because that is a worry to quite a few people because we can't account for them. They've kind of disappeared into thin air.
Yes. Well, that's not a power that's been afforded to me. Again, that's a power, I think, that a question that one could direct to the ordinary courts. It's not a power that's been given to me. It obviously is a matter of concern. It will become easier, I think, once the process for government to get information from self-owned companies will assist government in working out perhaps where these people have gone. As I say, at this stage, it's still very early days, and this process is not yet fully up and running.
Now, you've said earlier that it's not been a week yet. You haven't gotten information. We've seen today in newspapers such as the City Press that government intends to have, 100,000 tests being conducted. Now, obviously, in instances like that, you will have the CSIR that has the central collection and data processing center up and running, where people will obviously, their information will be required. Do you expect to be quite busy in the next coming weeks? And how are you going to make sure that, the process is properly managed, considering that the volume will obviously increase as the testing and mass testing increases?
Yes, I think that's right. I think this, like all new systems, this is somewhat untried, and it's pretty clear from government's response that they intend to continue refining and considering how best to address the pandemic. I think there are questions of how to contain the disease and the spread of the disease, but there are also related and arguably along the way the more important questions of how to be able to ensure that we can go back to some semblance of normal life, that the economy can restart again without risking the possibility of a sharp increase in the number of cases. So these are questions in which governments all over the world are trying to determine what is not only the rights-respectful way forward, but what is an effective way forward. And I think that there's a lot of common learning happening at a very rapid rate, compared to the normal rate at which government make laws and respond.
Yes.
With an enormous amount of this happening. So I do expect this to be a developing situation, and for us to see refinements and amendments of these regulations going forward. And indeed, that's one of the key powers that the the designated judge has here, is to make recommendations to government in ways that will seek to both protect privacy, but at the same time not impair government's ability to respond to the pandemic.
How do ordinary citizens interact with the judge designate if they, for example, suspect that their information is being misused? Do they have recourse to you directly?
That's not, as I say, again, this is not the nature of the role. There, I think, if you think your information is being improperly used, it seems to me that either you'll approach a court or certainly take legal advice as to what to do about it. It's pretty clear that if that information were to be sought to be used in a court case, a judge would make it very plain that that would be impermissible. But at the moment, that is not a role that is being, my role is merely to vet it. And until I start seeing the information coming through, it's quite hard to predict exactly how best to deal with this. But I think one needs to bring a kind of audit eye on it. And make sure that the information coming forward is brought in a way that can be assessed and, as it were, reviewed and audited. And I think it will be a matter I'll be considering in the weeks ahead.
Now, this is, of course, new for you. We've never had a situation like this. Do you relate directly to the Justice Minister? I know you're obviously going to have a relationship with the Health Minister, but what is your kind of accounting lines in relation to the Executive?
Well, I was appointed by the Minister of Justice and Correctional Services, as is provided for, and so obviously that would be one line of communication between me and government. But the next important line will be between me and those responsible for the compilation of the COVID-19 database. And then the third line will be in relation to the recommendations I made, which will be the Ministers of Health, Justice and Cooperative Governments and Traditional Affairs.
Now, you said earlier that once the disaster is, over, information can be accessed. But what happens to the information that is collected? Presumably, government will always have this information, or are they meant to let go of this? I'm assuming that, given the fact that we're living in the era of COVID-19, it would be a good idea for government to have information like this on a database. What happens to the information once COVID-19 is over?
The regulations are clear about that. They make it clear that the database must be, all personal information held on the database must be destroyed. And not only that, but government and those responsible for the database must report both to Parliament and to me on what steps they've taken to destroy the database. There is one exception to that, and that is that there's a provision which allows de-individualized or anonymized, I assume, information on the database to be retained for research purposes. Given that the pandemic is the first pandemic globally for almost 100 years, it seems important to learn as much as we can from a scientific perspective about the spread of the disease and in terms of understanding exactly what is happening and what has happened, to assist in the responses to pandemics going forward.
Absolutely. Uncharted waters. Thank you so very much to the designate COVID-19 judge, Judge Kate O Regan. Let's take a short break. When we come back, Water and Sanitation Minister Lindiwe Sisulu joins me to discuss the water situation in poor communities amid the coronavirus outbreak. Don't go anywhere.